Hi, my name is Angela Princeville, and today I want to talk about what you can expect to accomplish at your settlement conference, sort of going over the goals and purpose of a settlement conference. I had talked in my last video about the case conferences and what you can expect to accomplish in those. So if you're just getting started in the court process and you're the first time you will be going in front of a judge, more often than not, will be at your case conference. So you may want to check out that video. But the next attendance, for the most part, is usually a settlement conference. And the settlement conference, just like the case conference, is a chance for the judge to see how they can help the parties narrow their case. Settlement is a very important aspect of all of the conferences, and as the settlement conference, from the name, as the name implies already, it's the goal is really to see how the courts can help the parties narrow their issues and settle whatever issues still remain in dispute. By the time you're getting to a settlement conference, the courts would expect that the parties have completed disclosure. At the case conference, you would be expected to have provided, a lot of disclosure up until that point, and whatever is outstanding, usually the judge would, make orders. The parties can enter into it on consent, or timelines can be made by the judge and when disclosures should be exchanged by the parties. But by the settlement conference stage, a few months have gone by since your matter started, and it's expected at this point that substantial or almost all of the disclosure ought to be ought to have been exchanged. And this is significant because without disclosure being fully exchanged, you may not really be able to take full advantage of your settlement conference, which, as I said, the name implies it's trying to see if your case can settle. Because at the settlement conference, if your case doesn't settle at that stage, then what the judge is going to do is put your matter on the trial list. So, for example, if this is happening, earlier in the year, you may find yourself being put on the May trial list, as an example. And so, the more prepared you are, the more disclosure has been exchanged, the more the issues are narrowed, the better the chance of avoiding a trial, or even going to a trial with the issues that you're discussing being focused. You also, at the settlement conference stage, is where you would discuss with the judge on, your expert reports. At the case conference, chances are the courts would have mentioned to the parties what issues that they have that would require expert evidence to resolve. Um, at the settlement conference stage, the courts will want to see, well, are there any expert reports ready? How close are you guys to sort of settling the issue, or just setting things down, and when can expert reports be expected and things like that. Again, if the parties get some of these reports, it could really help in narrowing the issues, and that's why these things are important at the settlement conference stage. So in with the goal of trying to help the parties settle at a settlement conference, and a lot of cases do settle at this stage, the judges would give you their recommendations. They also do at the case conference, but at the settlement conference stage, there's been more disclosure received. The parties, there's probably been a lot of exchanges between the parties. Each party's case has been explored fully, each party's issues. So the judge would be in a better position at this stage to give you recommendations on how they think your matter would proceed. Obviously, it's just a recommendation. At the conference stage, the judge doesn't have the benefit of having received the full evidence, but they've received a lot more. The parties have exchanged a lot more disclosure at this point. Things are a lot clearer, and you get the input of the judge as to, well, if they were the ones deciding the case, how would they decide? At the settlement conference stage as well, the part of the purpose is to see, well, what else can we do to sort of move this matter along. So anything else that would again help towards settling is something that the judge would look at. And the judge would look at what evidence would be presented at trial, in what format would it come, how much time do the parties need for trial, and if you don't settle at the end of the day, scheduling you for the next trial sit-ins. If the parties, if there's no settlement at the settlement conference, you would expect, you should be expecting to book a date. Some courts work differently, but for most of the unified family courts, there would be a date scheduled for your next conference, which would be the trial management conference. So again, the main goal of the settlement conference is to try to settle. And if your matter isn't settling at the settlement conference stage, then expect to attend a trial management conference, which would really, and expect that at the settlement conference, your matter would be put on the trial list, which means that you are going to trial. The part of the main thing that you can accomplish when you go to the settlement conference is if you can't settle all of your case, then are there certain issues that you can agree on? How, at this is a good, that would be a good time to think about, well, what issues can I concede here? What issues are not worthy to take to trial? Just so that we can narrow it and you can focus on the issues that mean the most to you. And if you need to go to a trial on those issues that matter most to you, that's what you do, because it's better when you can settle as much or concede things that don't mean the most to you while you have a trial that's, or move to the next stage with the things that matter the most to you, and advance that way. So that's my tip. When you go into a settlement conference, please be prepared to settle. It's very important that you have an offer to settle. Whatever compromises you can make there, fantastic. Even if none, put forward an offer to settle, because it's actually required that you do that. Okay. Anyway, I hope that was helpful. And on my next video, I will talk about trial management conferences.